Hello and welcome. I'm Alexander Theo Harris.
And I'm Peter Smith. Thanks for having me.
It's your podcast too. Today we're going to be talking about trademarks, all manner of things regarding that amorphous thing that people always seem to want.
So before we get into the details of the trademark, we do have to say we are both attorneys, yes, but this podcast is for general education only. We're not providing anybody with specific legal advice for their specific instances.
Right, we are attorneys, but we're not your attorneys. And if we are your attorneys, you should probably come talk to us.
Right.
So for starters, we're going to talk through what a trademark actually is. A trademark is a source identifier. It's something that tells the consumer or the public where something came from, what brand it is. If you see a Mercedes-Benz car, you know that it has some level of quality because it came from the Mercedes-Benz factory, and you have some previous knowledge about what it is you're getting.
And then from the company's side, right, Mercedes-Benz doesn't want anybody else to use the Mercedes-Benz mark because they spend a lot of time, energy in that quality control, developing an amazing product, so they want to protect their brand.
Exactly. So a trademark is the exclusive use of a particular identifier. That identifier could be a name, it could be a phrase, like a catchphrase, or it could be an image, like a logo. It could also be some other things, but that's probably for another session.
And what's interesting is that the law, while granting somebody the exclusive right to use a trademark, has to have some limitations. It can't allow some specific words within an industry to be taken off the table. For example, I think of the word software when I think of this, right? So a software development company can't trademark and gain exclusive rights to the word software. It'd be unfair for the rest of the industry. In addition, we have to limit the rights by as far as you provide somebody with notice, right? So you could have a trademark right in a word and be a local shop, but only insofar as you provided notice to people that you're using that specific phrase or word or trademark can you protect the rights in it.
Exactly. The whole point is that people identify this as something that comes from you. So if you haven't gotten to the point where people identify it in that way, you're not really promoting your brand.
Some of the elements in order to gain rights in a trademark are that you use the mark in commerce, that you actually start to use the mark. You get protections as far as you provided notice about it, and you have to make sure that your mark is actually something that is protectable, right? It's not too descriptive or generic. Those are the legal terms for something that would wipe out, wouldn't allow the rest of the industry to use a particular turn or phrase.
And as far as you've provided notice is the important bit here. So if you are going to register at the USPTO, the United States Patent and Trademark Office, the benefit that you're getting is you're putting the entire nation on notice that you are making some claim to this mark. So everybody should know that you, Microsoft, are intending to be the Microsoft. And anyone else who wants to infringe on that territory has to go pick something else.
Right. And so before you can go to the level of registering with the USPTO, your mark has to be used in commerce and it has to be crossing state lines, right? So the federal government only has jurisdiction once your goods or services in relation to your mark are moving across state lines. So for example, cannabis, we're in Washington State. There are folks who have legal licenses to grow and sell recreational marijuana. But the federal government doesn't recognize that, and certainly cannabis can't cross state lines, so it wouldn't have any jurisdiction over marks in that area.
Exactly. But it doesn't mean that you can't register your mark. It just means you can't register your mark with the USPTO. You could still register your mark at the state level and give protection within the state because you're putting everyone in the state on notice. So for something like cannabis, that could be a good alternative.
One other thing I want to point out, Alexander, while we're talking about this, is that your exclusive rights to use a phrase or source identifier only extend to the category or industry that you're using your mark in, right? So Microsoft, I could go start maybe a haircutting salon and call it Microsoft, couldn't I?
You could try. Microsoft would still probably try to cause some concern for you. But in theory, yes, you could go start Microsoft haircutting and should be able to start using that mark because Microsoft doesn't have, well, aside from at their Redmond campus, they don't actually work in that space. They're only trying to make software, and if you were using that name for something else, you should be fine. That's similar to Apple Music, which was the record label, and then Apple Software, which was, of course, the famous software and hardware manufacturer. Yeah. They're both using the name Apple, but they're in two different industries.
Right. As we've mentioned, just by using your mark in commerce, getting it out there, you gain some protections insofar as you've provided notice. And it goes back to the date when you first used your mark in commerce. The problem is that people forget. Memories change, memories fade. Nobody really knows exactly when you started to use your mark or how far you've given notice. So registration can be incredibly valuable because now you've got a date certain. You've got an actual physical piece of paper that says, "Hey, I've got a trademark. I've registered it."
It's got a beautiful foil stamp on
It's
it.
got a very beautiful foil stamp. Some people do it for the stamp. And you can sort of take those common law rights, those amorphous rights, and really dial them into something way more tangible by registering.
The other benefit of registration is that it makes it so much easier for you to sell your asset or license your asset. Because you can clearly show, hey, I own this. I have rights in this mark. It makes it simpler to go to some other company and say, hey, if you want to use my mark, I'll grant you a license. Or if you do want to sell your company, it's very clear that this is an asset that you actually have.
Good. So let's talk about the process of registration a little bit, Alexander. I know you do this in your practice quite a bit. Walk me through it.
So what we typically do is we start by going and searching for the mark. We try to see anything that could be close to it that could be what we're concerned with, which is being confusingly similar. If something is too similar, if something is too close to the mark that we're trying to register, we know there's going to be problems. And those problems may not be that somebody else has already registered the mark and they're going to contest it. It could be that lots of people out there are using similar marks and haven't registered. So we go both through the USPTO Gazette, through Google and Yahoo and Bing and every search engine you no longer hear about. We search on social media. We look everywhere to see if there's anybody else using something similar to this mark.
So what you're saying is that if it's a crowded area around the words or logo that you're using within the same category, it may not be wise because you're going to be later than those earlier people using something similar?
That's right. But it also means that somebody else out there, as we discussed earlier, you could just have some rights in the mark even if it isn't registered. So if somebody is in that space and they have been for a while, it's going to impact your ability to register.
I see. And the word you used there, sort of the buzz phrase, was confusingly similar. It sounds like that'd be hard to figure out.
It is hard to figure out. It's a bit of a subjective test to see whether something sounds similar, whether it looks similar on the page. You don't know how somebody's going to say it aloud, so you sort of have to assume that they're going to say it the wrong way, even if you're trying to spell your word in a particular way to evoke a particular feeling. It could end up being that, you wrote down MSRFT
instead of Microsoft spelled out.
And lo and behold, that's close enough because somebody could end up pronouncing it Microsoft just naturally. If it sounds similar, looks similar, if you're in similar channels of trade, if you have similar goods, that kind of thing, all of that can contribute to being confusingly similar. There's a whole list of tests, and it really does come down in some cases to the trademark examiner who's going to look at this and say, yeah, these two are too similar. I'm not going to let this go through.
So that leads me to a couple of interesting questions, but first I want to point out that confusingly similar has a lot of tests. You just mentioned some of the different factors that goes into it. Strong rule of thumb: would a consumer looking for a product within that industry or good or service within that industry be confused between the two similar marks as to who is the actual creator of the good or service?
And that's definitely the biggest thing. Is somebody out on the street going to be confused by this? In fact, one of the things you look for is how sophisticated the consumers are. If it's something in a highly regulated industry where you're selling only to people who have, PhDs, only doctors can buy this particular type of chemical, there's going to be a little less scrutiny and you can sort of bleed over a little more compared to something like selling bars of soap in a supermarket. Because the consumer is just going to be readily making a quick decision, grabbing it right off the shelf without paying too much attention, it's more likely that things could be confusing.
Back to the registration process, how much does it cost for me to go register my mark and make it more tangible?
It depends on a couple factors, but you're probably looking at about $275. That's the hard cost of taking it to the USPTO and saying, hey, I want that foil stamp piece of paper.
And that's per mark that I want to register, right?
Good point. So that's not, hey, I have this mark, I want this. It's per mark, per category. So if you choose to make bouncing balls, that's one category, probably toys. But if you're also making bouncing balls brand software, like video games about bouncing balls, that's going to be a totally separate category. And that's going to be two registration costs, so $275 twice.
Great.
Also, if you're registering both your name, Bouncing Balls, and a logo that shows a bouncing ball, that's two separate marks as well. And if each of those are being featured for both of those categories, you're now looking at 4 marks, or 4 times that $275 hard cost. So, of course, that's the filing fee cost, but in addition to that, you're going to have legal costs on top of that to actually make this thing go forward. In a lot of cases, a tremendous number of cases, what comes back is something called an office action. The office action is a letter from the USPTO that says, here's the problems we have with your mark. Give us a response to see if we can overcome these.
What sorts of things would they be able to respond back with? I guess my question is, what can't be a trademark?
Office actions could include stuff like asking that you limit the scope of what it is that you're registering for. Maybe your bouncing balls toys are fine as long as it's not bouncing balls for children under the age of 2. Things like that. Limiting the scope, narrowing it could be the kind of things they ask for. They could ask you to change part of your mark, or they could ask you to disclaim part of your mark. Maybe bouncing balls is fine, but you can't have the word balls. So you're mostly protecting bouncing balls as a whole, but if it's just the word balls on its own, you're not going to go after somebody. That kind of thing.
So we talked a little bit about the limitations on registering your mark with respect to scope and the categories you can get into. Are there any other restrictions that business owners and trademark holders should consider before trying to protect a particular phrase or maybe drawing or mark or something like that?
Yeah, absolutely. In addition to checking to see if it's already out in the world, you want to make sure that it's a strong mark. And the strength of the mark is sort of categorized in one of 5 different categories. At the lowest level, it's called a generic mark. Generic marks are things like cereal or software co or aspirin, things that are just descriptions of the object itself. If you are trying to trademark the word apple in regards to your fruit farm, that's generic. You're just talking about apples. And if you were to take that word away from commerce, there's no means of referring to apples anymore. So you're not going to be granted those kinds of marks. The next level up is descriptive. Descriptive marks describe the thing that you are providing, the product or service you're providing. So something like speedy delivery is a descriptive mark. Microsoft is even a descriptive mark because it's talking about microprocessor software. American Airlines. It's an airline that's in the US. They're American Airlines. Those are descriptive. They're stronger than generic marks, but they're still not great. Next up is suggestive. Suggestive marks evoke some idea in the imagination of the viewer or reader. So stuff like Blu-ray, Burger King. It's talking about, oh, they're really good burgers. These are the king of all burgers. Coppertone, suntan lotion. These are suggesting what the product does. Now we're getting to the really strong stuff. And the strong stuff starts around suggestive and really gets good at arbitrary and fanciful, which are 2 of the best categories you can get. If you're looking to register a trademark, this is really where you want to be. Arbitrary marks are where you take some word that's totally unrelated to the product or offering you have and apply it there. So for instance, Apple computers. Apple is certainly a fruit, but it has nothing to do at all with computers. So Apple computers, arbitrary mark.
Well, what's interesting is that I have a strong association with that word Apple to mean software and hardware products.
So as more time goes by and as the consumers begin to associate that, you get that secondary meaning as well. Fanciful marks are words that are just not just arbitrary. It's not just we took the word apple and threw it on computers. It's we made up a totally new word. This is something nobody has seen before, and we're going to own this word. Something like Kodak. Kodak is not a thing. It's just a word that they now apply to cameras and people know and love. Xerox is another example. Totally fictional word that is now applied to copy machines.
Oreo for a cookie.
Oreo for a cookie. Yeah.
Or maybe fanciful, I also think of the Nike swoosh, right? It has nothing to do with anything related to sports if you think about it, but it's so related to that brand now. I don't think anybody could have a swoosh on anything else and not have a consumer think of the company Nike.
Exactly. By way of example, a generic mark would be something like cereal. A descriptive mark would be something like tasty cereal. It describes the way the cereal tastes. A suggestive mark could be something like sogless crunch.
Delicious.
Mm-hmm. It evokes something in the mind of the listener, saying, oh, well, that's probably something that stays crisp, even in milk. Next up would be an arbitrary mark, so something that doesn't refer to the product at all. Something like bicycle cereal. So bicycles have nothing to do with cereal at all. Totally arbitrary.
So the bicycle brand cereal.
Bicycle brand cereal. And, of course, the strongest is going to be fanciful marks. So something like...
just a picture of a bike could be fanciful. Or, even better, Gorgle Snort.
Gorgle Snort cereals. There's marketing people who are going to come up with better campaigns around that. Those are just examples if you want to use those. So one thing I do want to mention here is if a name becomes too associated with the product. So obviously you want to trademark because you want to be able to protect that idea in regards to your brand. But sometimes brands bleed over into being just so dominant in an industry that people just start using that as the generic word, the thing that they're trying to describe. That's called genericide. We see this with things like Xerox. People for a while, and there was kind of a big campaign by Xerox around it, people for a while were trying to use the word Xerox just to mean copy machine. Hey, can you make me a Xerox of this? Kleenex is another one that had the problem. Can you grab me a Kleenex? People weren't saying, can you grab me a Kleenex brand tissue? They were saying, this word means this thing, which impacts the brand negatively because it makes it less likely they can protect it. Nintendo, at one point, had the same problem. They were running ads showing, their characters saying, hey, you're not playing Nintendo, you're playing Nintendo brand games. A Nintendo is not a thing. If a word does become too generic, it loses all of its protection entirely. This has happened with things like escalator. Escalator used to be a brand, and now it's just the generic term for a powered staircase.
It's for an escalator, right?
Yeah.
Escalator brand powered staircase. I think the idea, though, is that trademarks are an asset and a right under the law that you can protect forever, for as long as you use in commerce. And that's a good point, right? Is that the law will provide protection for your trademark, for you to be the exclusive company or person using a trademark, so long as you're using it in commerce. As soon as you don't use it in commerce anymore and you quote, abandon the mark, it's up for grabs, anybody can use it. But unlike, say, a patent or perhaps a copyright where there's a timeline, there's a shelf life, trademarks could last forever. And so that's why we were mentioning this risk with escalator and I think aspirin and some of the other examples.
Shredded wheat, I think, was originally a brand.
Right. Some of the things that you've mentioned, that you could lose those over time if they just become the generic thing. All of a sudden, that is the industry, right?
Exactly. So if you've had a copyright is good for, I think, 70 years plus the life of the author at this point. It keeps changing depending on when Mickey Mouse comes up for renewal. Patents are good for 20 years if you renew them. A trademark, on the other hand, you register it, you get it for 5 years. Between the 5th and 6th year, you have to pay a $125 fee to show continued use, and they give you another 5 years. But you can keep doing that indefinitely. There's no end date for, well, now you have to stop using this, unlike copyright or patent.
Exactly. You just have to, so long as you're using it, you've got rights to it.
Which makes sense. If the world at large associates your brand with this product, it makes sense that you'd be able to continue protecting that as long as you keep using that product and making that product.
So one of the last things that we should mention about trademark rights and having a trademark is that we mentioned if you stop using it, then you're going to lose, the law is going to say, well, you've lost protection in this rights. That also matters if you stop policing your marks. So if you have the right to use a mark, you have to demonstrate that you're going to enforce your exclusive right to use the mark. Because the law is basically just like with, no longer using it in commerce. They're going to say, well, if you're not going to stop others from using this in your trademark in commerce, then why should we step in and stop others from using your mark in commerce? So there is a requirement to make sure that other people aren't using your mark or are using confusingly similar marks to yours.
So that's called policing your mark. It's where you go out and make sure that other people aren't using your mark. And if they are, you have to do one of a couple things. One, you have to tell them to stop. And if they're not willing to stop or things aren't working out that direction, you can also talk about making a license with them where they accept that, yes, this is your mark. We'll pay you a fee to continue using it for our purposes. That happened, I think, with the Droid cell phones. Droid cell phones, I think, pay a license fee to Star Wars. I guess Disney now. For the use of the word droid.
Right, makes sense. And I've had clients do this too, where they're policing their marks. They see somebody else using their mark, something confusingly similar to their mark. They're not sure if people are being confused or not, but they don't want them to be. So they enter into some sort of joint use agreement or some sort of agreement to say, hey, so long as you're not going to expand into my market or target my people, you can continue to use something similar to what I'm using here because we're not afraid that consumers are actually going to be confused. And ultimately, if you can't enter in some sort of license or joint use agreement and they continue to infringe upon your mark, you're going to have to bring suit to stop them or risk losing your mark. And that makes sense in the grand policy of trademark law as well, because if there was two Mercedes-Benz brand cars, then the original Mercedes-Benz brand is allowing somebody else to dilute the good of their service. There's no longer a need to differentiate themselves.
That's all we have time for today, but join us in the future. We're going to delve more into trademarks and this sort of larger topic. If you have any questions or want to chat with an attorney, visit our website, apexlg.com. We're happy to talk. I'm Alexander Theo Harris.
And I'm Peter Smith.
Thanks for listening.